355 million Kenya shillings is no little money. In this case, the developer had what might have been a strong case against KRA. But none of that mattered because the developer asked for extra time to submit additional documents. KRA provided that additional time, but the developer missed even that deadline entirely. And what the developer tried to do, they tried to argue that KRA had taken too long to respond to them, and that argument did not work. And this judgment explains exactly why. In the previous video, we spoke about Isli Mall, which won a massive case purely on the basis that KRA had missed the 60-day deadline to object on the decision from Isli Mall because they took 22 months in that case. Today's case is a mirror image of that case. Here, a developer tried to use this same argument but failed completely because the 60 days clock only starts if you lodge a valid objection with KRA. And the objection was never valid in the first case because they never submitted the documents that they had promised KRA that they were going to submit. The central tax question in this case is one that affects every off-plan property developer in Kenya. And the question is, when is a customer deposit to be treated as taxable income? The current developer collected over 1.9 billion in customer deposits on apartments that had not yet been built. And the developer argued, quite reasonably in this case, that you cannot tax money because they may have to refund that same money to the people who have provided it in case they are unable to provide the houses. But KRA disagreed entirely and issued an assessment of over 355 million. The challenge here is the tribunal even never had a chance to even agree or disagree with either of the parties on who was right on the tax. And by the end of this video, you will understand the exact documents that are required for a valid tax objection. You will understand what happens when you miss a document submission deadline to KRA and why the 60-day deemed allowance rule does not apply in case the objection that you made to KRA is invalid. Additionally, I will tell you what the law actually says about off-plan deposits and when these deposits become taxable. Because even though the developer lost as a matter of procedure, the underlying question is very important for every property developer in Kenya. Rama Homes was an off-plan property developer. They were selling apartments even before the construction began. What would happen is that buyer would sign letters of offer, they would pay the deposits, and then they would wait for their units to be completed. So they would pay, go home, and wait. In the accounting records, Rama Home did the correct thing. They record all these deposits from customers as work in progress. They reported them as a liability, not an income. Because correctly, they owe these people that money. Because the contract that people had signed stated that all these deposits were refundable. And this is very common because if the building is never completed, the money would get returned to all those who wanted to pay for the off-plan properties. For the years 2017 and 2028, Rama Homes declared very little revenue, just a few million shillings. But when KRA looks at the books, they're seeing huge deposits coming in. At around the same time, Rama Homes reported massive cost for approvals for the building, architectural fees, and for the cost of construction. The result was, even though there is a lot of money in the bank, the company declared a loss of over 1 billion shillings, which the company carried forward year after year. In effect, Rama Homes paid almost no corporate tax, even though it's receiving billions from its customers. And when such an anomaly happens, KRA begins to take notice. Before COVID came knocking on our doors, KRA started the investigation. The letters went back and forth between Rama Homes and KRA. KRA wanted to know if you as a company have collected 1.9 billion in customer deposits, why are you only declaring like 6 million in sales? Now, for Rama Homes, they explained very clearly that it was an off-plan developer. They also explained that no unit was ready for occupation. And under accounting standards, you can only recognize revenue when the risk and rewards of owning that specific property is transferred to the buyer. And this transferring this risk to the buyer only happens once the units are completed, but the risk does not pass just because a deposit has been paid. KRA was not convinced by that argument and subsequently issued an invoice totaling 355 million for those 2 years. Rama Homes knew their rights. So what they did, they filed an objection for both years, and they did this within the 30 days window. And so far, so good. The objections from Rama Homes were on time. Under Section 51, subsection 3 of the Tax Procedures Act, a valid objection must do at least three things. First, they have to state the grounds clearly for the objection, pay the undisputed tax, or request an extension for time to pay, and thirdly, submit all the relevant documents. So those things must be done. Now, Rama Homes sent some of the document, they sent some of the records, but they didn't provide everything. KRA wrote in around April 2020 requesting additional documents from Rama Homes. And some of these documents included their audited financial statements. They requested all agreements with the property owners, and they also needed a breakdown that is matching cost and to income. Around this time, as luck or not luck would have it, COVID hit. Rama Homes wrote to KRA asking for an extension to around May 2020 so that they can be able to provide the outstanding documents. And the reason was because of the pandemic, they are not able to get to the office and also coordinate with different clients. Now, because it was a pandemic, KRA understood. They agreed and gave an extension by email on April 23, 2020. Now, May 4 came and went. The next deadline came, and Rama Homes submitted nothing. They requested an extension, but they did not provide even a single file, even a phone call, even any explanation. From Rama Homes, they went all silent. I think they were somewhere hoping KRA will never remember. In July 2020, KRA issued what is called a decision on the objection. But it was not a substantive decision on the tax. It was an invalidation notice. It is stated that the objection had never been validly lodged because Rama Homes had failed to submit all the relevant documents despite being given an extension. And because of this, the original assessment was confirmed. And for KRA to show how serious they were, they issued agency notices to the company bankers instructing them to collect 186 million directly from the company accounts. And it's at this time Rama Homes became stunned. From their point, KRA was definitely wrong. So they did what every company would do and they appealed. And it seems they were in for a rude shock.